But the decision was right. It was founded in constitutional law. And the fact that some of these other people supported it, it's fine with me. And final digression, you won't find any hundreds of thousands of dollars in any election this year. As mentioned in passing, the laws of Washington allow, I think, $1,600 contributions. The system has changed, and so I rely on lots and lots of people, which is why the earlier references to the Grange and the Farm Bureau, and yes, the Belders out there. They're mostly small and medium-sized businesses, and I've been strongly supportive of them throughout, and they'll support me.
So how much have you raised?
Under $80,000. I expect it'll run probably in the mid.
People?
Pardon?
From how many people?
I don't have that number. Sorry, I know last time around when I did.
What's your largest donation?
$1,600. And there may be some 32, a couple, I think 3 people have contributed, assuming that I had a general election, which I do not have. So I know last time I had more individual contributors than anyone else. It was something around 4,000.
Mr. Rumbaugh, how much have you raised and from whom?
Last I checked was about $43,000, $44,000, $45,000. The contributions have been largely $1,000 or under. I do have friends that I've known for years who have, both husband and wife, have contributed $1,000 or maybe $1,500. Those are not very many. I can't give you a more specific breakdown right now than that. I'm sorry.
I just looked at the PEC site this morning.
Then you
Oh,
can
good.
give
Well,
me
I didn't write down the numbers, but both your numbers are in the range that I remember. But you haven't had any expenditures yet. Is that just?
There'll be expenditures. The bills come due, and you pay your bills.
Okay.
That's
So you've spent some money, but you haven't got the bills and paid them yet.
they're being paid. You know, there's an organization that we hire to do the PDC reporting. They're an impartial accounting bureau, and they pay the bills and they make the filings, and that's their expertise.
I thought maybe you're holding all your money for one push the last week. Okay,
no.
all right.
When you listed your accomplishments, none of it involved judicial experience. Is that important for someone sitting on the Supreme Court?
Well, I have the same amount of judicial experience that my opponent had when he went on the Supreme Court. As a matter of fact, of the 9 sitting justices, 5 of them had no prior judicial experience prior to being elected to the Supreme Court. I've certainly had plenty of litigation experience, and I've sat as arbitrator on 40 or 50 cases where the parties have selected me to resolve a dispute in a non-jury trial format, in sort of an alternative dispute resolution format. I've been selected both by the court and by private parties to serve that function. But as far as on the bench judicial experience is concerned, Justice Johnson, same with Justice Charles Johnson, Justice Sanders, Justice Chambers, Justice Fairhurst, none of them had any prior judicial experience in the context that, in the sense that you're talking about.
But there is a difference. What we do on the court is analyze particularly constitutional matters and write. And the difference is, as I've said before, and I said when I came here 6 years ago, I'd done almost 100 appellate cases in the federal courts of the 9th Circuit, 8th Circuit, and DC Circuit. I'd done over 30 cases in our Washington Supreme Court at the time I spoke to you 6 years ago, cases in all 3 of our courts of appeals, and in the United States Supreme Court. I did 7 cases in the U.S. Supreme Court with Slade Gorton alone. And so the writing and the analytical approach, it's writing and writing. It's a different thing from trial work. I love trial work. And we were talking about fun, nothing like fun like being in a jury trial, for example, but that is not appellate practice. What we do is write, basically, analyze and write.
I write virtually every day. Briefs for the trial court, briefs for appellate courts. Probably in the last 10 years, I've been to the Court of Appeals or the Supreme Court. It's a small firm, so we all work collaboratively on these appeals. A dozen or 15 times, I don't have the exact number for you, but at any point in time we have a couple cases pending in some appellate court or another. I think we even have a petition for a review pending at the Supreme Court right now. It keeps you abreast of the rules, but using the law as a tool every day and seeing how it affects people's rights in real time, in the courtroom, in hearing rooms, and yes, in the courts of appeals and in the Supreme Court, is the best way I know of to keep your tools sharp and keep your analytical skills at a high level. If you make a mistake, you lose. And when you're in private practice, you need to be able to adequately brief the law and be at the very cutting edge of the law, so you know where that is and how you can appropriately advise clients and individuals about where something is achievable and where it's not achievable. So the downside for writing briefs, doing research, I wrote a brief over the weekend, is that if you get it wrong, you really get it wrong. There are consequences for that. I think that having extensive experience as I have had in the trial courts gives you a great sense of how the record that is ultimately reviewed by the courts of appeals, by the Supreme Court, is actually made. Being involved in the push and pull of litigation, where you have a trial judge trying to create a fair atmosphere for the litigants, 2 or 3 or 4, however many happen to be in the case, is an important dynamic to understand. Understanding that juries not only listen to testimony and see evidence, but they form impressions about things that happen in the courtroom that in real time are much easier to understand and grasp than looking at a cold printed record where you're just trying to discern what happened at the trial court, whether there was error, whether something egregious or improper happened, than if you just write briefs all the time. I think that on-the-ground experience is very important.
On a scale of 1 to 10, how would you rate the quality of our Supreme Court now? And what qualities would you bring to shore up the deficiencies you see?
That to me, I think that our Supreme Court is probably getting a passing grade at 7.5 or 8. I would bring, as I alluded to earlier, a centrist attitude to the court, a desire to implement the laws as they were written. My opponent has talked about not legislating from the bench and how he promised that he wouldn't, yet in numerous cases he's been called out by the legislature and by his fellow justices for that very type of judicial activism. In the Totem Electric case, there was an interpretation by Justice Johnson in his majority opinion, a 5-4 majority, that imposed federal disability law on a disability claim that was brought in state court. And not only did the legislature the very next session impose a statutory remedy to say, no, that's not what we meant, that was not our intent, and we are going to make it clear in this legislation that our intent is to apply Washington disability law for our citizens. They also rebuked Justice Johnson for violating the constitutional separation of powers, and it's not made up. You can go right to the decision and to the legislative intent section in the books and read it. In the SEIU versus Gregoire case, the minority criticized Justice Johnson in his majority opinion for not just deciding whether a particular writ applied, a writ of mandamus applied, but for talking about legislative issues about what should be funded and what shouldn't be funded. And the state does have money, it doesn't have money. Certainly, you know, fiscal restraint, particularly in these times, is important. But the legislature decides how the money is to be spent. Whether they choose to spend it wisely or foolishly is not the province of the court to decide. That is a violation of the separation of powers.
7.5 to 8, would you agree?
Pretty close, actually. I hope that that's right. I've already told you part of what I thought I brought to the court. I work full-time at the court. Not all of us do. I live in Olympia, so I work full-time. 2 clerks, I'm proud to say, 2 Harvard Law School graduates. I like to bring back kids who've left Washington and gone to Eastern schools. I did that once too, and not everybody comes back here. So I think I've added analytical approach. I've mentioned once in passing the Victims' Rights Amendment. There were no cases involving victims. There are now since I got in the court. And to correct one, I'm proud of one recent case I did. I wrote a dissent. It was a kiddie rape and kiddie porn case. And the court held that the statute prohibiting kiddie porn would only allow 1 charge, even though the fellow had several computers with 8 different movies, essentially. And I said, no, the victims are victims. Each one should be separate. And I wrote the legislature ought to change this. And contrary to the impression he's trying to leave you, the legislature came back, cited my opinion. You may remember one of the statewide officers picked up one of my lines, which is there should be no volume discount for kiddie porn.